Good morning everyone. This is the third lecture on Union Executive and the topic will be ordinance making power of President. In the previous one we have done about President and its power. Legislative power, judicial power, military power, emergency power and executive, all of the power done, emergency. Yes. So the major what we have in syllabus is also ordinance making power of President. Starting with what do we mean by ordinance? So, ordinances are like a law but not enacted by the parliament but rather promulgated by the President of India. So, they are promulgated by the President of India. They are not just like a simple law which is enacted in the parliament. And it is promulgated when Lok Sabha and Rajya Sabha, they are not in the session. Union Cabinet's recommendation is a must for an ordinance to be promulgated. Using ordinance, immediate legislative action can be taken. So this is what ordinance mean. That ordinance, they are like simple law, but not enacted by the parliament. Rather, they are promulgated by president. And when it is promulgated by a president, when Lok Sabha or Rajya Sabha or either of those, they are not in session. That is ordinance. Now, in our constitution, article 123 deals with the ordinance making power of president. President have many legislative power and this power is one of it. So article 123 of constitution, it empowered the president to promulgate ordinance during the recess of parliament. Now these ordinances have the same force and the effect as an act of parliament. They have the same effect as any law made by an act of parliament. But they are temporary in nature. These ordinances, they are the nature, they are temporary laws. So ordinance making power is the most important legislative power of president. We have done the legislative power in the previous one under the heading power of president. So ordinance making power is also a part of legislative power of president. So it is given to him to deal with the unforeseen or urgent matter. If there is any urgent matter, if there is any other situation, unknowing situation, any urgent matter, for that this is vested in him. This power is vested in him. But there are some limitations to the power as well. It's not a complete power, but there are many, in fact, many limitations. If we start with the first point, he can promulgate an ordinance only he can promulgate the ordinance in the three circumstances: when both the house of or either of the house, they are not in session, already told. Then circumstances occur when the president think it necessary to act without waiting for house to assemble. When there are some circumstances, or when he can make an ordinance when he is satisfied that the circumstances exist which make it necessary for him to take some immediate action. Now in this case, in this point I have added, the last point is Cooper case. Now in this one, the Supreme Court held that president's satisfaction can be questioned in a court of law, in a court on the ground of mala-fide. Supreme Court said that his satisfaction, this is what the third point was saying, circumstances occur where the president think it necessary. He think it necessary. When he is satisfied, this means when he is satisfied that there are the circumstances which exist that render it necessary for him to take some immediate action. For this, Supreme Court held that president's satisfaction can be questioned in a court on the ground of mala-fide. Now what does this mean? This means that decision of a president to issue an ordinance, it can be questioned in a court on the ground that president has prorogued one house or both house of parliament deliberately with a view to promulgate an ordinance on controversial subject. Now An ordinance can be retrospective in nature. That is having the previous effect from. Parliament has to approve ordinance within 6 weeks from its reassembly. Before the house get reassembled, Parliament has to approve the ordinance. Not before, after the reassembly of the session of the Parliament. After it, within 6 weeks, the Parliament has to approve the ordinance. So his ordinance making power is coextensive. Then also, if there is every ordinance which is issued by the President during the recess of Parliament has to be laid down before the House of Parliament, both the House of Parliament, when it reassembles. And if the ordinance is approved by both the houses, it becomes an act. And if Parliament takes no action at all, ordinance ceases to operate on the expiry of 6 weeks. If it does not approve, if the Parliament does not take any action, then automatically the ordinance will cease to operate. Right? Even the ordinance can also cease to operate even in the earlier, within the prescribed 6 weeks. In this case, it happens only if both the House of Parliament pass any resolution disapproving it. So what does this mean? That the maximum life of an ordinance can be 6 months and 6 weeks. And in case of non-approval by Parliament, 6 months being the maximum gap between the two sessions of Parliament. And the President can also withdraw an ordinance at any time. So, the first point in this slide, that unlike Indian Constitution, most of the democratic constitution of the world don't give such ordinance making power to their President. It is not given. In India, we have given this power under Article 123. Then it has no connection with the President power to proclaim a national emergency. Of course, it does not have any connection for it. If I exactly read what is 123, if I tell you, 123(1) says, listen to it carefully, that exactly from the Constitution, Article 123 clause 1 says, if at any time except when both the House of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. Very clear, as explained. Then 123 clause 2 says that an ordinance promulgated under this article, it shall have the same force and effect as an act of Parliament. Again clear. But such ordinance has to be laid before House of Parliament, and it shall cease after the expiration of 6 weeks from reassembly. And before the expiration of that period, resolutions disapproving it are passed by both houses upon the passing of second of those resolution. And it can be withdrawn at any time by the President. This is what whole the 123 article says. It's very simple, very short. So, the ordinance making power of the President, it is unusual and not found in most of the democratic constitution of world. Like in USA, it is not there, and UK. In justification of this ordinance making power of President, the framer of the Constitution, Dr. B.R. Ambedkar, he said in his Constituent Assembly that the mechanism of issuing an ordinance has devised in order to enable the executive to deal with the situation that may suddenly and immediately arise when Parliament is not in session. This was said by Dr. B.R. Ambedkar. So it has to be noted and clarified that this ordinance making power of president, they have no connection with the national emergency which is given under 352. And president can issue ordinance even when there is no war or an external aggression or armed rebellion. This comes under emergency. We'll deal with it in the topic when we'll be doing about national emergency. But till this, just remember that it does not have any connection with national emergency. Now, the following limitations. President can promulgate an ordinance only when both houses are not in session. And yes, this is there. For an ordinance to be promulgated, such circumstances should be there which deem it necessary for president to legislate through ordinance. Now here, the rules of Lok Sabha, they basically require that whenever a bill is seeking to replace an ordinance is introduced in the house, there are statements with explaining the circumstances that have necessitated immediate legislation by ordinance. They should also be placed before house. Till now, in Supreme Court, there has been no cases gone on repromulgation of ordinance by president, but the judgment of Supreme Court in DC Wadhwa, I have mentioned it, DC Wadhwa case. Do read it. DC Wadhwa. It is extremely important. Now, what happened in the case? The court pointed out that between 1967 to 1981, Governor of Bihar, he promulgated 256 ordinance, and all of these ordinances were kept in period from 1 to 14 years from 1 to 14 years the ordinance were kept by repromulgating from time to time. It was done by Governor of Bihar. Now the court ruled in this case that successive repromulgation of ordinance with the same text without any attempt to get the bill passed by the assembly, this would amount to the violation of constitution and ordinance. So if such ordinance is repromulgated ordinance, it is liable to be struck down. So the court clearly said such ordinance so repromulgated is liable to be struck down. Conclusion was that it was held that exceptional power of lawmaking through ordinance, it cannot be used as a substitute for legislative power of state legislature. We can't use it as a substitute of legislative power of the state legislature as it happened in Bihar. So DC Wadhwa case is highly important. Then 38 Amendment Act, it inserted 4th clause in 123 which states that president, first I'll tell you what 123(4) says. It states that president's satisfaction by promulgating an ordinance was final and could not be questioned in any court on any ground. But after 44th Amendment to Indian Constitution, it got revised and made the president's satisfaction to bring ordinance justiciable. So earlier it was said that president's satisfaction, it could not be, while promulgating an ordinance, it cannot be questioned in the court. But then later it said yes, it opposed it. So ordinance can be introduced only on those subjects on which Indian Parliament can make laws. Another point, it can only be introduced on subjects on which Indian Parliament can make laws. Ordinance cannot take away any right of citizens which is given under fundamental right. This is also important. Any ordinance if framed cannot take away the fundamental right given under, enshrined under Part 3 of the Constitution. Then ordinance ceases to exist if Parliament takes no action within 6 years. This is already told. So maximum life of an ordinance is 6 months and 6 weeks. The case DC Vadva is very important. Do see to it. It was a time, in this case, court simply held that the exceptional power which is given through this ordinance to the president, it cannot be used as a substitutive for legislative power of state legislature. You can't use it as a substitute and make a law and keep it and repromulgate it. From time, this is what it happened. From 1 to 14 years, he kept it by repromulgating it. So court held it to be, if such ordinance is made, it could be struck down, clearly struck down. This is what was an ordinance, and that's it. The major points. Thank you. In the next one, we will be doing about Prime Minister. Thank you.